field is saying about English law, but I'm willing to bet that in Swiss law there will be a similar rule applied. And then finally, can the CAS award be challenged in court? This is a subject of which Ben Olbourne will be speaking in more detail. I'll just mention the vast majority of CAS awards are classified as international because of the relevant time. At least one party has neither its domicile nor its place of residence in Switzerland. Under the Swiss statute, the award can only be set aside by the Federal Supreme Court of Switzerland in the following circumstances. If there's an irregularity in the appointment of the arbitrator, if the arbitrator erroneously rules on his jurisdiction, if he goes beyond the claim submitted to him or fails to rule on one of its claims, if the more or less equivalent to the natural justice, if the treatment of the parties or rights to be heard are not respected, or if the award is incompatible with Swiss public law. These grounds, as most of you will know, bear a very close relationship to the grounds on which you can challenge an award under the UNCITRAL model law and the New York Convention. And it's also reflected in Section 37 of our Act. As to how the Swiss courts, so it does mean there is no appeal to the Swiss courts on a point of law. So to get an arbitration award set aside by the Swiss court is very, very limited. And just finally, the Supreme Court recognizes that public policy, this is the Supreme Court of the Federal Supreme Court of Switzerland, public policy is not the same as domestic public policy and is more narrowly construed. That is where the award would be contrary to fundamental legal and moral principles recognized in any civilized state. So it's very difficult to get it set aside on public policy grounds. On enforcement, Switzerland is a signatory to the New York Convention, so awards can be enforced through the New York Convention in any country which is a signatory, and that's almost every country in the world. So with that, I'd like to hand over. I know Ben Olbourne is the next speaker, and he's going to be talking about a much more exciting subject, which is controversy arising out of a particular case. Thank you.
Thank you, Dato Davidson. Very informative speech indeed. Our next speaker we have lined up for you has been described by Chambers of Asia Pacific as being an eloquent, very up-to-date on the law, and able to play up to the strengths of the case to the best advantage. We are indeed privileged to have with us today Mr. Ben Olbourne, a practicing barrister and arbitrator. Mr. Olbourne is a member of the English Bar since 2003 and has also been admitted in Australia. Mr. Olbourne provides advocacy and advisory services across a broad range of international, commercial, public international and public law disputes in England and other jurisdictions in both court and arbitration proceedings. Mr. Olbourne is recommended for his work as an arbitration counsel in both the Legal 500 and Chambers and Partners directories. Mr. Olbourne is also a fellow of the Chartered Institute of Arbitrators and has been appointed as an arbitrator over numerous disputes under various rules including the ICC, the LCAIA and SIAC rules. And I believe that Mr. Olbourne will be sharing with us today his experience in international arbitration, as well as what is mentioned by Dato Davidson, a very interesting new case on the challenge of jurisdiction of CAS by courts. Please, let's put our hands together to give a very warm welcome to Mr. Olbourne.
Good morning. I do have some slides to show. Someone might be able to help me with setting those up. But I'll make a starting event.